Welcome everyone to the once a month, second Thursday, 2 o'clock truck stop webinar. We present these every month at 2 p.m. We'll send you information concerning the one we're going to do in April. We're putting that together now. Just make informational fact, this is not approved for CE credit. These webinars are for informational purposes and to keep you current on things that are happening in the industry itself. We do have webinars that are presented every the first Tuesday of every month that does qualify for CE credit, and you can go on our website and look at those if you need CE credit. But again, this does not meet the requirements for CE credit. If you have any questions of the presenter, notice on your screen there's a chat window, and you can list the questions in those chat window, and we will attempt to ask them as we go along if we have time. If we do not have time, we assure you that we'll answer all these questions for you after the webinar. We'll send you direct answers, and we'll share the question and the answers where appropriate with everybody who's online. If for some reason we have some technical problems, please call our office at 800-741-4084, and we will attempt to correct any problems, or you can put them in the chat window. We have had some technical problems in the past, and we just want to make sure that you are aware of how to handle those things. Now for the program. I have my colleague and friend, Bren, who has been a great assistance in everything that we have done under the Motor Carriers Insurance Education Foundation to assist us in this program. So I'm going to turn this over to Rich. Rich, take it away.
Thank you, Mr. Ruke. Not that it's relevant necessarily to this group, but you're in multi-states. Mr. Grandys and I coming to you from the great state of Arizona this morning. This is a great opportunity for me to bring a former colleague and friend to this program today and share. Scott Grandys, as I read his bio and share some information to you, you will see truly is a subject matter expert when it comes to independent contractor topic. Now, as we come together today in the TRS program, keep in mind what the R stands for, risk. And so what I want you to do is you listen, and if you're an insurance company person or an agent that's helping motor carriers, think about how this impacts your customers. And if you're a motor carrier attending today, look at your own business and realize the impact that this could have to you. As we get through this program, about 3/4 of the way into it, Scott is going to give you some slides, and he's going to talk specifically about your ability to take this now, your understanding from this. How can you take it out and apply it? How can you educate others? So think about how you're going to capture, apply, and then later teach some people. And Scott's going to help round this out at the end. And his contact information, in case you don't gather all this, as you know, Tommy records this, you'll be able to access the slides. But Scott will be on the TRS webpage under the contributor section, and that's where you'll be able to obtain his contact information if you don't capture it from the slides today. Now, again, I come back to the point that I called you risk managers, consultants, help, assistants in how you're talking to your customers as you talk about deductibles and things, or their retention programs, right? But sometimes you have to talk about that which is uninsurable. And I believe this group, this TRS group, has a passion to protect their customers and to help these businesses avoid that which could be unexpected and catastrophic to their business. In this misclassification issue, this topic can be exactly that, catastrophic. And I'm not trying to say the sky is falling, but just look at any experience that you've had or vicariously learned through others that, sometimes a workers' comp audit is a great example where the independent contractor issue can be brought to the forefront and hit a motor carrier hard. Tommy was talking just before this launched as a reminder. He's involved in a couple of workers' comp audits right now, six-figure additional premium charges that are going on because of now the desire to bring the independent contractors in. And so as a reminder, some resources that are out there on the TRS website, some blogs of the past talking about application of occupational accident and how to keep things clean with your underwriters as to whether or not they'll accept that, et cetera. So we're just sharing that as part of the dynamic as you're looking at independent contractor topics, and think about what Scott's saying today and how some of this can help you build a stronger case and a better barrier to those issues arising. And as we go into the future, as this Affordable Health Care Act comes along, think again about the potential hazard of a classification of a group of independent contractors suddenly now moving into the employment realm, and how that could impact a motor carrier that now is required to bring that along in the fines and the penalties. So as Scott goes through this today, I'm gonna forewarn you, it's like drinking out of a fire hose. There's going to be a lot coming at you, state issues, federal issues, various agencies in that, and it's a multi-level attack, for lack of a better term, upon your customers, upon those that use independent contractors. Now, Scott Grandys began working in transportation almost 2 decades ago with Sonic Air Chicago, and there he learned the independent contractor model and how vital it was to that company's success. After Sonic Air was sold to UPS, Scott worked to gain some additional corporate experience with the UPS same-day program. Scott's also been involved with a company called Central Air Freight, where he worked to provide IC solutions through a complete implementation of the independent contractor model into that company's transportation structure. Scott and I met when he was the Chief Strategy Officer for Contractor Management Services. And Scott worked there hand in hand with legal, compliance, technology, sales, to coordinate and educate their client companies, bringing independent contractor experts, industry experts, and the independent contractors themselves together to talk about compliance and the proper usage of the IC model. So again, with over 19 years of transportation industry knowledge and experience, he has a wealth of experience and industry specific to transportation application of this knowledge. At Relevant Business Solutions, where he is now the CEO, Scott's using all that experience and specific to transportation to deal with the ICM model and developing services that are going to help companies keep their independent contractor practices current. So one of the things that he does is educational, and we're thankful that he's sharing some of his wisdom with us today. But he also provides an online platform that will allow subscribers to be alerted and to be able to research and find critical events that are happening that could change the best practices that they're currently using. So with all of his background and with all of his experience, Scott's been tapped by many industry association groups, including the Air and Expedited Motor Carrier Association, the Truckload Carrier Association that had him on the Independent Contractor Division, the Express Carriers Association, Governmental Affairs Group, involved in the Massachusetts Delivery Association with the New England IC Steering Committee. He's been involved with the Independent Contractor Task Force of the American Trucking Association, and also with the National Federation of Independent Business Arizona chapter. So that all being said, you're thoroughly prepared to know who this guy is, and we're cutting into his time. There's a lot of great information to share, so I'm going to turn it over to Scott. Welcome, Mr. Grandys, and thank you for joining us today.
Well, thanks, Rich. I appreciate the intro, and Tommy, I appreciate the opportunity here to share what's in my head and what we see going on in the marketplace today. So thank you very much for that. And with that being said, we'll jump right in and get started. So we'll start, and I'm just going to tell you a tiny bit about us so they understand kind of where all of this information is coming from and what we do to understand the depth of data that we're sifting through to bring you what you're going to hear today. So our company is 100% focused on dealing with independent contractor issues. We are also 100% focused on transportation. So we work in the trucking space, air freight forwarding, courier, taxi, and limousine. So if it's got wheels and it's on the ground and it's moving things, we're dealing with the independent contractor model in those spaces. Rich, as you had mentioned, we've got a subscription-based website that tracks all of this data and keeps people up to date. We also have educational programs and consulting services and risk assessment programs that we offer to our clients. So that's just kind of a very, very brief overview of us, and we'll jump right into the detail here. So what do we see in the marketplace today, and what is the real problem? And really what we're seeing in one word is summed up: confusion. And if you take a look at the picture on the left, it's kind of a funny little graphic that I like to point out. because with the IC model, what we typically see in companies is it's always funny and it's always a joke or it's always a sideline issue until you're next, and then it gets serious. And so what we typically see in the marketplace is companies will have a singular focus on their IC issue. So since we're dealing with insurance on this call, let's talk about the renewal of their workers' compensation or their occupational accident insurance programs. So when a motor carrier comes up and it's time to deal with that, their focus is 100% on making sure that their IC model makes sense under the workers' compensation laws. But in most states, there are 4 different divisions that they have to be cognizant of and potentially 4 different tests that could apply and cause risk. So it creates confusion again because there's only a singular focus. And in every state, as well as the federal government, the agencies have different tests. They have different case law that interpret those tests. And so again, it creates confusion. On top of that, in the motor carrier space, as I'm sure all of you know, regulation passing down from the federal government has been on overload. And so that becomes the flavor of the day as far as what motor carriers need to pay attention to, and the IC risk kind of falls to the wayside. And all of that does is it creates gaps in several parts of the motor carrier's company. The operational gaps that exist between what happens in reality and what happens in their documents. You've got premium gaps between workers' compensation and occupational accident insurance, and clearly if somebody has a misclassification situation, there's going to be legal costs that they haven't contemplated to defend their company and protect themselves against those misclassification claims. So that's kind of what we see in general in the marketplace. So what we're going to go over today is a lot of information on the independent contractor model, and I like to start by telling people this because a lot of times the information gets a little spooky, it gets a little overwhelming, and sometimes people feel a sense of helplessness. So I want to make sure that everybody today remembers this. The independent contractor model is completely legitimate and completely legal. It's been around for hundreds of years in the United States. If you think back to Wells Fargo and the Pony Express, or the attorneys like Abraham Lincoln that used to offer their services to others back in the day, it's been around forever. The Small Business Administration reports that there's 28 million small business owners in the United States, and there's a branch of the government, the Small Business Administration, that deals with small business owners. It's what's made the United States an economic powerhouse on a global market, and it's fueled by the entrepreneurial spirit and the American dream in the United States. So I like to just remind everybody that even though we're going to go through some stuff that might be a little scary and might make you feel a little helpless, remember this is a legal model. You just have to pay attention and do it right, and we'll get to some of that later on in the presentation. So what we're going to cover today, we're going to go over a legislative update. There are 21 new bills that are targeted towards employment, independent contractor, or misclassification since November of 2013. I'm not going to dive into every one of them, but I will kind of give you some overviews on what those bills have inside of them. There's a couple new laws that we'll go over that have been brought into play and are effective in 2014, and we'll discuss those. We'll go over generally the state and federal case environment that exists out in the marketplace today. I want to spend some time talking about the Department of Labor and kind of their direction and what they're doing, because I think it's important for everybody to be aware of that. And then we'll close with just some helpful hints and some takeaways that you can either apply to your motor carrier clients, or if there's any motor carriers on the phone, you can apply these in your daily operations. So we'll start with the legislative update. So here's where we're at. 21 bills since November of 2013. And I think only the two federal bills were initiated or introduced in 2013. The remainder of these bills were introduced from January through as recently as yesterday. And quite frankly, I have to keep changing this slide because the number keeps changing. So this is basically where everything's at. You'll see a couple of states have multiple bills going, and we'll talk about that in a little bit more detail later on, but most states just have one bill that's out there. Okay, so the typical bill terms, let me dive into this a little bit. So instead of going into each and every one of these bills, which would take quite a while, what I'm going to do is talk a little bit about, what do you typically see in these bills that are being introduced as frequently as they are. And so a lot of what we're seeing are new tests. So whether they're coming out, and this seems to be kind of a flavor of the day as well, if you will, these multiple factor conjunctive tests. So 6-part tests, 10-part tests, 11, 12, sometimes 21 parts. So you've got a situation where the legislature seems to be trying to give some direction through some very specific factors that need to be met in order for a worker to be determined to be an independent contractor. We also are seeing some bills that are coming out where they're going to assign one test for all the agencies. And when I refer to all the agencies, the blanket that I throw over that is workers' compensation, unemployment, tax, and wage and hour. So there are some states that are introducing legislation for one test for all 4 agencies, which is very helpful as well because it starts to clear up some of that confusion we talked about earlier. And then we're also seeing some bills that are being introduced where they are introducing new tests, but you still have the multiple tests in one state. So the 4 divisions, again, may have different tests that are out there for each one of the divisions. Another typical thing that you're going to see in these new bills are the penalties and fines. Most times they'll have civil and criminal penalties that are included. They vary in the number of in the dollar amount for the penalties and fines. In many states, you're also seeing included in the bill incarceration clauses, so fines up to a certain dollar amount or up to a certain number of days in jail for violations of misclassification. Also, another thing that we're going to see, and we're going to talk about this a little bit later when we get to the Department of Labor, and I think it's an important point to highlight, is transparency. In almost every one of the bills that comes out, there are clauses about transparency to the workers and what rights they may have as an employee versus an independent contractor, transparency about the penalties that the employers will be responsible for if they're deemed to be misclassified, giving public notice in a public place inside of the location for the employer. And then we're also seeing retaliation clauses, and we'll get to this under one of the federal bills, but where there are protections built into these bills for 1099 workers so that they cannot be let go, they cannot be fired, and there cannot be any sort of a retaliation against them. So moving on, some of the other things, again, under the transparency part, there are some bills that are out there that are alerting these workers that they have a right to sue, meaning that they have a right to damages, potentially double or triple damages, which we'll talk about in a minute, and it gives them that right expressed through the bill, as well as contact information for the state agencies so that they know who they can contact in order to get clarification on their classification or report some sort of a claim on their classification. Again, some other things that are being included in these bills are increased audit authority. So the ability for the agency that the bill may be falling under, again, one of those 4 agencies, to conduct audits on companies that they believe are misclassifying workers. Many of them also include interagency communication. So for example, if it's a workers' compensation claim, they can communicate that information to the Department of Labor under the unemployment side so that they can conduct their own investigation. Or potentially, if it's an unemployment claim, they can communicate with the tax department so that they can conduct their own audit as well. Some other things we're seeing are separate tests. When we talked about a couple different tests under the same state, under the same agency, are tests for specifically to classify yourself as a sole proprietor or a separate business entity, and those are different from classifying themselves as an independent contractor. So again, kind of another frequent thing that we see in these new bills, as well as we're also seeing in some of the bills where the states are trying to give one agency, whether it be the Workers' Compensation Board, whether it be the Unemployment Board, the right to handle all misclassifications for the 4 different divisions that I mentioned earlier. Okay, so those are the typical things we see. I'm going to now bring up some red flag things that you'll see in some of the bills that are out there today. So, for example, in Rhode Island, there are 2 bills, one on the Senate side, one on the House side, which I've listed here in the presentation. And in those bills, they changed the test to a new 21-factor test from the IRS test. And one of the things that's a little bit dangerous in this bill is they include the language, they put in the language including but not limited to the 21 factors that they list. And so what this does is it creates wiggle room for the agencies if this becomes a law. And one of the things I want to talk about here very quickly is what people need to realize is once the law is out there, even if it is a good law and it's passed and it's got a clear test, the concern that we have and that we see, and the problem that we see, is the agencies have a certain level of freedom to interpret that new law how they see fit. So when we see language along the lines of including but not limited to these 21 factors, it gives some freedoms to the agencies that are a little scary, because in order to really straighten that out, a company needs to get into the courts to define what that new law truly states. So that's why that phrase is a little concerning when it's some of these bills. The other thing that we see are modified ABC tests. Now, the one that really concerns us the most, and we'll see this in Minnesota, it's in New Jersey, and it's in the new law that we're going to talk about a little bit later in New York, is the modified ABC test that modifies the B prong of the test to be a singular way to pass it, meaning the company has to be outside the line of business of the independent contractor, and it removes the other portion of the B prong, which was, or they provide all their services outside the facility, which is typically what the transportation industry relies upon. But when you take out the or portion of the B prong and you remove the or outside the company's facilities, it becomes problematic. And if any of you have dealt with the situation in Massachusetts, that modified ABC test is what's caused all the issues out in that state. So that is appearing. It's in the new New York law that we'll talk about. It's in this Minnesota bill, and it's in a couple of other bills as well, and it's a little concerning. Now, the other thing that is concerning is the multiple tests under the same agency. And I'm going to go back just for a second to the ABC test. And I want to make sure that everybody understands what the ABC test is. And sometimes I forget to go through these things. But the ABC test is a conjunctive test. So a company has to meet A, B, and C in order to classify the worker as an independent contractor and exempt from employment status. The A prong of the test deals with control and direction. The B prong of the test is what we talked about a little bit here just a minute ago, which is a company has to either prove that the worker is in a different line of business or that they provide all of their services outside of the company's facility. And the C prong of the test is the independently established business portion of the test. And again, it's conjunctive, so a company has to prove all three factors in order to pass the test and have that person exempt from employment. Okay, now we'll go to the multiple tests under the same agency. So here's the problem we see here, and we're going to talk about this one in New York with the new law there shortly. And it's also a situation in Minnesota, Ohio, and Washington in their bills. So what happens is these new bills are including language that says if you passed, for example, in Minnesota, this modified ABC test, then you can be determined to be an independent contractor. Or you can pass an 11-factor separate business entity test and be determined to be a separate business entity. So what that does is I'm going to go back to this leverage that an agency has once a bill becomes a law to interpret things kind of loosely in their favor. So until it's taken into the courts, when you have multiple tests under the same agency that have two different types of classification but they're in the same line, and from our view and from what we've seen, it creates concern because it's not as clear-cut as the law should be, in our opinion. And then the other thing that we're seeing, and it's not in any of the bills that are out there today, but it was in the new law that came into play in Illinois in 2014, and is effective in 2014, and the new law that's effective just a couple of days ago in New York, which creates individual liability for corporate officers and or managers that know about this independent contractor misclassification issue. Okay, some other things to watch. I bring up construction for this reason. This bill in Ohio right now is targeted at construction, and quite frankly, the new law that went into play in Illinois, which we'll talk about in a minute, was also targeted at construction. But construction is defined in this Ohio bill as including moving construction-related materials to job sites and removing construction-related materials from the job site. So that means if you've got a flatbed carrier client who's bringing in lumber to a job site at that point in time, they are classified as construction, and this bill would apply. As well as even if it's a dry van and they're bringing in something that is going into the construction of the building, even though they're not in the construction industry, the way that the definitions are written, at that point in time, if they're delivering those materials or picking them up, they are in the construction industry. So you got to be careful of those in these bills as well. There are also some bills specifically in New Jersey that are removing transportation-specific exemptions and just removing them from the law, which again is going to create some concern for companies that are relying on those exemptions. Willful violation language is pretty common as well. We're seeing it in this Washington bill that's out there. And it defines, the reason willful is concerning is because it's defined very broadly, and it's along the lines of the person should have known that they were violating the law, and that is what is considered willful, and typically it comes along with heftier fines, heftier penalties. We're also seeing double and triple damages. The reason this is concerning is because what it does is it creates a platform and a venue for plaintiffs' counsel to make more money on filing things like class action lawsuits, because they can get double and triple the damages that were actually there. And then multiple bills simultaneously. So I want to cover this because what's concerning here is sometimes as bills are moving through the legislature, they will introduce bills simply as placeholders and then amend those bills to change the language, and it catches people off guard. So when you see something like Missouri, who has two different House bills out there, neither one of which really has any fundamental change language in them, but they're introduced days apart. It's a little concerning when they sit still because you never know what the legislature is going to do, and we always advise people to pay very close attention to those bills because they could change and they could cause a problem. The other thing we see is as you see on the screen here in New Jersey and Rhode Island, when you have two different bills introduced, one in each chamber of the legislature, what we typically see there is they're trying to save time by introducing the same bill with the same exact language in both chambers of the legislature, because now it doesn't have to go from one side to the other. Essentially what they do is as they both pass each chamber, they substitute one bill for the other because they're the exact same language, and then it goes off to the governor, and it's a much faster way to get a bill through. So when we see those, we like to raise a red flag for companies to pay attention, because what it means is they're serious about getting this bill through. Okay, next thing we're going to go through, and a few more things to watch, then we'll move on to the courts, is bills that fail or are withdrawn. And the reason I bring these up, and there's two in Wyoming and one in Mississippi right now, the reason I bring them up is because it's a sign. And it's a sign that the state is trying to do something, but it failed. So when I see these types of bills, I also like to raise awareness, because it means that maybe this session it didn't work, they pulled the bills off the table, but pay attention next session, because it's starting to show that there's activity, and there's probably going to be another bill reintroduced, and they're going to try it a little different way to see if they can get it to go through the legislature. And then the last one that we'll cover here, which is another one that people typically won't think to look at, is appropriation bills. And I bring this one up in Massachusetts because it was a little bit slick what they were trying to do in this appropriations bill, and it's still live right now. Appropriations bills are typically out there just to set budgets and spending for the different departments within a state. This particular appropriations bill, 3867 in Massachusetts, actually codified a new division underneath the Department of Labor labeled the Underground Economy Division. And so people would look at it and say it's an appropriations bill. I really don't need to pay attention to it because it's just talking about budgets. But what it did is it actually created a new department in the Department of Labor, or it's attempting to do that. So sometimes you've got to look at bills that you may think are a little bit outside of the realm of independent contractors because they may apply. Okay, now we'll step into the two federal bills that are out there. So if any of you have listened to the hearings when these bills were introduced, what the federal government is trying to do is take control of this misclassification issue by entering a couple of bills into the system. So Senate Bill 1706, which is titled the Fair Play Field Act, what it's doing is it's attempting to remove the current 530 safe harbor and replace it with something a little bit different. Essentially, this bill is really not all that bad. But again, one thing I encourage people to do is just watch the bill, because they amend these things and you want to make sure that it doesn't take a hostile turn on us. So what they're looking for, just like very similar to the safe harbor today, is making sure that there's been consistent treatment of workers as independent contractors. They were reported that way to the federal government, and that they had a reasonable basis to classify workers as independent contractors, which is very similar to the 530 safe harbor that exists today. The reasonable basis, companies have to rely on some sort of judicial precedent, a letter of sorts, something that they could show to the agency to say, this is why I did these things. And the past IRS audits, if they didn't include an assessment of the workers' classification, then those don't apply any longer. And then long-standing is defined, and we'll talk about that in just a second here, and making, they can see that the industry uses this practice, and that will still continue to have, the new term of safe harbor. And then the consistent treatment, again, what they're going to look at is to make sure that there were no taxes imposed for similarly situated workers after December 31st of 1977. Additionally, in the bill, they're going to continue to use the typical common law that we all know today. They've got some carve-outs for skilled workers. You can see here they're more the white-collar type workers. And then rules on treatment. So what they're looking at here is if you didn't have an employee treatment analysis in a safe harbor or some sort of a no-change letter that you may have post December 13th, 1996, then that does not apply any longer. It has to specifically address the employee treatment analysis through the IRS. I talked a little bit about defining long-standing industry practice. They're looking at making sure that it's more than 25% of the industry is using independent contractors, and they're not putting any stipulations that it has to be more than 10 years or if it started after 1978 that it's problematic. So again, some good things that are in this bill. Burden of proof, what they're basically saying is a company has to cooperate in terms of an investigation or an audit, and if the company proves the things that we just talked about, the long-standing relationship, the reasonable basis, all of that, then the burden of proof is on the secretary to show that they are actually employees and not independent contractors. Okay, a couple more things here. I'm sorry, I just skipped ahead a slide here. There are some other exceptions for other reasonable basis. If you have a prior safe harbor letter, again, as long as it had that treatment test, the employee treatment test in it, it will stand. And then the department's also going to come out with some model language about the tax obligations as an independent contractor, awareness of their, again, this transparency of their rights as workers, and then an understanding that they can go to the agency and they can request some sort of investigation to find out if they truly are an independent contractor. And then down here at the bottom, also what the bill wraps in is some pretty specific reporting. So they want to make sure that the federal government gets annual reporting on misclassification, independent contractors, and how big the problem may or may not be throughout the country. And again, you'll see here, then they get into actual statistical valid data to make sure that they've got a full scope of what's going on in the country today. The other bill that's out there, which you may or may not have heard about, is the Payroll Fraud Prevention Act. And basically what this bill is trying to do is it is trying to extend protections under the FLSA that typically were only given to employees, W-2 employees, and it's trying to wrap in now to expand that definition of a covered individual to people that are classified as 1099 workers under the IRS. So basically, things that we talked about earlier, it's wrapping in retaliation and discrimination protections. It's giving double liquidated damages, extending civil penalties, and also trying to publish, again, through this transparency, the rights that workers have as an employee versus a non-employee, as well as expanding unemployment audit powers by the federal government. So essentially, that's what this bill is trying to do. They posed it as saying that the federal government needs to step in and that they need to help states straighten things out and give them clear, concise rules and regulations, but they're not actually doing that. All they're doing is building protections for 1099 workers under what is typically an employment law. Okay, so we'll talk about new laws. The two new laws that are out there are in New York and Illinois. The first law, which just became effective 2 days ago, the New York State Commercial Goods Transportation Industry Fair Play Act. So a couple of things that I want to hit on here. One, it clearly defines commercial goods transportation contractors and services. Basically what it says is it's anybody that's transporting goods throughout the state of New York. They have a valid driver's license, and they have a commercial vehicle which is defined as a combination weight of 10,001 pounds or more, which is a caveat, and I want to add this in here. There is a current bill, 8451, on the Assembly side in New York, I'm sorry, the Senate side in New York, that just went to the governor, and the driver's license from commercial to regular and the gross combination weight, as well as under the next tab there, reporting people on a 1099. Those are technical changes that were made by the governor when he signed the bill back in January, so we suspect that those are going to go through any day now. And then what this new law also does is we talked about multiple tests under the same agency. So it applies to all agencies, the 4 different divisions that we talked about earlier, and it's creating an 11-factor conjunctive test, which we have some concerns about when you look at the factors, as well as that modified ABC test that we talked about in Massachusetts. And a company has a rebuttable presumption that their employees, until they prove that they meet all 11 factors, because it's conjunctive, or that they meet the modified ABC test, because that's conjunctive as well. Also in New York, what they've done is they're talking about making sure that persons receiving remuneration are getting notice of the rights that they have. Again, they want it to be displayed in the employer's, alleged employer's facility, make people aware of their tax obligations, make sure that they understand their rights as employees versus independent contractors, have contact information for the agencies. This stuff needs to be in place within the next 30 days, so if you have any clients or if you are a motor carrier in the state of New York, you need to pay attention to this, because if you don't have it in place, there are civil penalties that are attached for violations of noncompliance. As well as wrapping in, New York is wrapping in willful violations. And again, people should know, either knew or should have known that they were violating. You've got some civil penalties that you'll see here, criminal penalties, which include imprisonment or a fine based on the number of violations that a company has. And again, we talked about individual liability. This is wrapping in corporate officers that own or control 10% or more of a company. And it does not limit other remedies that may exist under different agencies. Okay, so we've got a question that just came in on New York, and it says, does New York law affect business in New York or business out of New York when their trucks are in New York? And that's a great question, and I'll tell you, arguments over venue happen all the time. And so really what that's going to come down to is a few different factors, and every agency and every scenario is decided differently, and it's going to depend on the agency you're in and or the case law that exists. So some of the factors are, what does your contract say with the driver? What is the venue paragraph in your contract as one potential scenario? Another scenario is, where did the driver spend most of their time providing their services? Another scenario may be, where was the driver dispatched from? And then yet another scenario may be, where's the driver's place of business? Where's that located? So again, it's kind of a confusing thing. It's a very, very good question. Unfortunately, there's no direct answer. And it all is going to come down to the facts that you have to point towards where the venue should be. If there's one recommendation I could give, it's make sure that it's clear in your contract where the venue should be. And make sure that you talk to your counsel about the best place for the venue as it relates to worker classification laws. Okay, and then the last thing is the new law in the state of New York includes retaliation, meaning that if somebody says that they feel they've been misclassified and they testify or they start a proceeding of sorts, a company, they're now, quote unquote, a protected class based on this new law, and you can't just get rid of them. Okay, Illinois, and I'm going to bring up Illinois very briefly, and it's probably one that people don't see on their radars, but this is the construction concern that I had with the bill in Ohio right now. This is the actual law, and if you look here at the caveat, the third bullet down, the definition of construction, this is directly from the law, shall also include moving construction-related materials on the job site or to or from the job site. So again, these new changes that have been put in place in Illinois, this definition has existed in Illinois now for 2 or 3 years, but transportation, trucking companies could get wrapped into the definition of construction if they're moving things to or from the job site, and the agency potentially could apply this law to trucking companies. So the new things that have been added, they just kind of did some procedural changes on response times and hearings and whatnot. They actually reduced penalties. And then the different thing that I've seen in this one is they actually, if the department brought an action against an alleged employer and there was found to be misclassification, the department will actually give 10% of the proceeds to the affected employees, which is something new. That doesn't exist in many, if any, states out there today. The rest will go to the Department of Labor to continue to fund their efforts. And then the other thing here, we talked about this a little bit earlier, there's individual liability that exists in Illinois. So officers or agents of the company that knowingly permit violations, except for there's something called the responsible bidder requirement under construction. If a company meets that, they're exempt from this individual liability. Okay, so we'll now jump into the state and federal courts. Again, I'm not going to go through all the cases because there are hundreds, if not thousands, of cases that we could spend days going through, but I'm just going to kind of go over the flavor of the day. And right now what we're seeing, the flavor of the day by far, without a doubt, hands down, is the Fair Labor Standards Act violations. So it gives federal protections, or depending on the state, which in their tax department or their wage and hour may reference the FLSA. It's usually the common law test. Again, if they're going to reference the FLSA, it is common law. They're typically going after minimum wage, overtime benefits, other benefits like vacation, sick, holiday pay, unemployment, 401k things, workers' compensation, health insurance, and a lot of times they're targeting improper deductions that shouldn't have been taken from somebody if they were an employee and not an independent contractor. Other things that we're seeing, class actions. I mean, I'm sure you've all heard about them. Typically, they're by a contingency fee attorney. Typically, they're going to be in a state that has some pretty difficult laws, and a lot of times you'll see, like, for example, Massachusetts, which was a big market and still is, there's triple damages there. So there's money for attorneys to be made, and that's where you're going to see them striking. They're usually going after one plaintiff or two plaintiffs and similarly situated and trying to create a class that way. The industries that we're seeing it in, and the caveat here is usually they're going after bigger companies, professional services, nail technicians. We've all heard about transportation. Exotic dancers seems to be a new thing that they're going after. We've started to see some saber rattling in the real estate industry. Oil and gas and construction has been on the map for quite a while also. So now we'll dive into the Department of Labor. So there's some activity in the wage and hour division that I want to cover here very quickly because it kind of goes to foreshadowing where the Federal Department of Labor might be going with their trends. So the wage and hour division of the Department of Labor upholds the FLSA. They have specific targets and web pages on employee misclassification as independent contractors. Many of you may have heard of the memorandums of understanding that they have with certain states. There's about 15 now. Typically what they'll do is they'll sign an agreement with the State Department of Labor as well as the Attorney General. They're also sharing information with the IRS. You can look at their newsroom. There's a lot of activity. And recently, as recently as September of last year, let me back up. The administrator spot in the wage and hour division of the Department of Labor has been vacant for 4 to 6 years now. The president has nominated Dr. David Weil for that position. I'm going to talk about him just very briefly here. He comes from Massachusetts. Has taught at the Boston University School of Management for the past 2 decades, has his master's and PhD from Harvard. I'm talking a lot about Massachusetts here because that's been a problematic state for a while. And specifically what we see here is he's been the lead technical advisor for the Massachusetts research study on the underground economy. He believes in targeted enforcement on misclassification, has been advising the president, believes in a fair day's pay for a fair day's work, and believes that the wage and hour division needs to switch its mentality to targeted enforcement as opposed to claim enforcement, meaning somebody's initiated a claim. A little bit more about Dr. David Weil. He was nominated back in September of last year by the president. The Help Committee, which oversees the Federal Department of Labor, had a hearing with him involved, and if you go to their webpage, you can hear that on December 10th. They approved him on December 18th. The last step before he becomes the administrator of the Department of Labor is the Senate has to vote on him generally. I've been watching it daily, and we haven't seen anything yet, but it should be happening any time now. Okay, a little bit about the 2015 budget, the fiscal budget that was just released last year by the president, last week by the president. In his message, he focused pretty heavily on jobs, saying that there's inequity that is deepening, average wages need to be raised, people are struggling to keep up financially, that there needs to be dignity for a hard day's work gets a hard day's pay. He wants to raise minimum wage to $10.10 an hour, which if you think about FLSA claims, if your minimum wage goes up by 50%, it increases the opportunity that a claim or a class action lawsuit will be filed. And he wants to invest in enforcement. Okay, a couple other things. These are right from the budget. They've put in there $11.8 billion in discretionary funds for the Department of Labor. It's for enforcement. They want to raise minimum wage, and they want to detect they want to protect workers and detect misclassification of employees as independent contractors. So there is a focus on that at the Federal Department of Labor level. It's built into their budget. If you look at the next bullet down, we talk about the funds that are dedicated to this directly. They want to increase the budget under the Federal Department of Labor by $41 million for the wage and hour division, add 300 new investigators across the United States, and currently they have $14 million to combat directly misclassification. $10 million of that is state grants if the states cooperate with the Department of Labor, and then $4 million it goes towards investigators that focus on nothing but worker misclassification. Okay, so we'll wrap it up here, and then we'll take some questions. So helpful hints. There's a lot going on. I want to focus back on that first slide that we have. This is not an illegal model, and people should not give up, but they do need to pay attention. And so education and understanding is huge. Understand the rules, the statutes, regulations, legislation, cases. People have to follow these things now. There's too many moving pieces, and the agencies and the legislature are getting smarter, and they're being influenced by organized labor. So it's important that companies understand what's happening, understand the bills that are out there, understand the legislative process. You know, the old PBS special on how a bill becomes a law. People need to understand that. Talk to the elected officials, help them understand and educate them on the industry. Educate your staff, other colleagues in the industry, and most importantly, educate your operations, understand what's happening there, and educate the independent contractors and understand what they're going through as well. On top of that, we always recommend consistent reviews. Companies need to frequently take a look at their operational practices, their documents, any internal processes and procedures that they may have for documentation, claims management, file management, meaning actual paper files for the drivers. All that stuff appears when a claim happens and a misclassification challenge of sorts comes against the company. And then look at educational programs. How do you teach the independent contractors what that means? How do you teach the employees how to deal with independent contractors? Those things need to be consistently reviewed to stay ahead of the curve in all this activity surrounding independent contractors. Get involved. You know, so many times what I see companies do all across the map is they sit back, and I'm going to go back to that first slide. You know, everybody thinks it's a joke until they're next. Not necessarily a joke, but they sit back and watch until they're next, and then it becomes a problem. So people need to get involved in their associations, support government affairs committees, support grassroots efforts at a state and a federal level. Get to know your elected officials and communicate with them. Teach others what's happening and why this model is legal and how hard the industry is trying to comply with all the confusing laws that are out there. Stay up to date. Watch the bills. Make sure the language doesn't change. Understand things that are going through the legislature. Understand what committee they're in and who you need to call. You need to stay up to date with all of that stuff. And one of the other things here, and it kind of goes with something I said a little earlier, people can't bury their head in the sand. It's not time to sit back and let somebody else solve this problem. It's time to get involved and understand what you can do to make a difference. And don't wait for others. You know, again, stand forward and help contribute to moving this thing in the right direction. Last thing is, you know, again, back to the first slide, this is a legal model. People can't give up. because that's what the government and the agencies are, and organized labor, they're counting on people giving up and switching to employee. So you got to pay attention. You've got to make sure you understand the laws. You've got to incorporate and embrace change in your company or with your clients. Educate others. It's important for companies to tell their story, why they're doing certain things. Help everybody understand those things. Again, consistently review. Encourage others to stand up and not give up as well. Push back on the agencies. If they tell you that something is being done wrong, push back and explain to them why you're doing it. It may be because of a federal regulation, and they consider it direction and control. Again, this is a legitimate business model, and this country was founded on the American dream, which is the ability to come here, start your own business, and be a success. And that's what the independent contractor model is all about at its core. So with that being said, we'll open it up to questions, and we can go from there.
This is Rich. I'm going to jump in.
Thank you, Scott. That was a... Go ahead, Rich.
I just, again, was starting to do the same. Thanks, Scott, for sharing your wisdom. And as we wait for some questions to come in, and please don't be shy about submitting them. As I said, there's a lot coming at you in this program. But thanks for the multi-levels and that which are coming about. Again, with the people that you've worked with, Scott, what do you see as, the maybe top 2 or 3 things that you're hearing straight from the motor carriers as you're working with people in the transportation? What is it that they're hoping you can get them out of, or they've seen, vicariously living through somebody else's bad experience? What are they most concerned about today?
Yeah, great question, Rich. I would say probably the biggest thing that is happening out there, the biggest 2 things. One are tax audits. So the revenue department within a state coming in and doing a full audit, going back typically 3 years to look at all the individuals that were classified as independent contractors and see if there are unemployment taxes due to the department based on misclassification. So that's a big one, and that typically, depending on the size of a motor carrier, could be hundreds of thousands of dollars, if not tapping into $1 million or more, again, depending on how large the motor carrier is and how large the wages were. And then the other thing that we're seeing a lot is just unemployment claims, which is typically what triggers the revenue department to come in and start to do an audit. So a lot of times the driver simply filing an unemployment claim, though that's a challenge in itself to defeat that claim, it also typically will lead to those revenue audits on the tax side.
On that last one comment, Scott, I found that that is very relevant. It's when your insurers, and most of our insurers we're going to be dealing with, Scott, are small or businesses. As you know, 85% or so, depending on what report you read, of people who are motor carriers in the U.S. registered at the federal level have less than 5 power units. So the great number of people that will be involved, where we will be involved, meaning the audience that we have here, will be smaller motor carriers who have a real concern here. What happens in this case, if I've seen it as a couple times you just mentioned, is that for some reason the driver feels he or she has been not taken care of properly, not right paid, something deducted, abuse a dispatcher or even the company owner. So then they go back and say, whoa, where's my unemployment? I can't work somewhere else. Could happen after their truck gets in a physical damage claim and they can't drive anymore, and they're looking out for unemployment, and they're bringing that up. And I think that's a real concern in those relationships, and I'm sure you found some of those, have you not?
Yeah, absolutely. That's typically what happens, is somebody feels that they've been wronged. They want some sort of a recovery so that they can fill the gap and when they don't have revenue coming in, and next thing you know, they file a claim, and now you're going down the slippery slope of audits and defending yourself. And again, what's unfortunate, I talked a little bit earlier about that gray area between when a bill becomes a law and somebody gets challenged by the agencies until they go to court. So, once you start going down the slippery slope of an unemployment claim, to an extent, you're kind of, relatively speaking, at the mercy of the agency to interpret these new laws as they see fit or as they see the intent was designed to be. And now you've got to challenge these things, exhaust your administrative remedies, and on a simple unemployment claim for somebody who feels that they've been wrong, now you've got to take it to the courts and let the judges decide on what the real legislative intent of the new laws will be. So yeah, it's a slippery slope.
And for you who are retail agents in this area, be very cautious or concerned about your risk, saying we don't want to cover them under work comp. We have them covered under OCAC policies. That is a legitimate way to protect the individual owner-operator themselves if they're truly owner-operators. But this is where the audits that I have come up with and that Rich mentioned earlier, and by the way, this is Tommy, has faced about that the work comp carriers not clearly understanding that they're not independent contractors, they're covered OCAC and not accepting OCAC as work comp. So one of the indications that we would have is when you have risks who say these are independent contractors, we're not covering them under comp, they are covered under OCAC. That's a trigger here. Again, OCAC's a good product. It can be used properly, and as Scott has mentioned many times, independent contractor arrangement is a legal arrangement. We just got to make sure we do it right. And the problem, one of the problems with OCAC, as same thing here with the definition of independent contractor, under the Work Comp Act, every state can be different. So you could qualify as an independent contractor in Florida but have an accident in North Carolina, or now even this new law in New York, and they would bring that jurisdiction into North Carolina or New York, and New York or North Carolina might say you're not an independent contractor, you're an employee. And that's a major exposure problem.
Yeah, and again, it's back to the question that was raised earlier, and that's a very, very good point, Tommy, is what's the jurisdiction? Who has jurisdiction over the claim? What does the contract say? Where were they injured? Where are they based? All of those things come into play. And again, you're right, on the work comp side, it becomes a slippery slope again. And anytime that you've got to justify things, it's those gaps in legal costs that I talked at the very beginning about that you may not have planned for, but now you've got to defend yourself. So, and the other thing is too, if you follow what's happening and consistently review your operations and your documents and everything else, if you are using the occupational accident insurance option as opposed to work comp, which is, again, like you said, Tommy, it's a perfectly legitimate option, but make sure that the carrier understands all of the things that you're doing to properly classify these workers based on the most relevant and the newest information that may exist in the states that you have that risk.
Well, again, Rich, thank you for helping me put this together. You got any final words you want to say, and then we'll get out of here?
No, I don't know if you got. Nah, we'll leave it. We'll do a summary follow-up. We'll have Scott throw something out there for you guys to help also understand that memorandum of understanding and how that audit can come back around. But we'll teach you. I'll have to follow up with that. Okay.
For you,
yeah, Rich, good point. I'll have a 2 or 3 page follow-up that'll summarize all this stuff. And you guys are free to. I don't know where the PowerPoint's going to be, but if people want the PowerPoint or if you have any questions, just feel free to reach out to me, and I'll be happy to share.
The PowerPoint will be on our web page, and Beth will send out to everyone who attended the information that Scott has. Also want to remind you at our annual conference in October, we will talk about the Work Comp Act and the problems with Work Comp and OCAC and misclassification. That's one of the breakout sessions that we'll have in our annual conference next October. They'll go in more detail and hands-on concerns about these things. Again, we appreciate y'all's attending this seminar. We hope, or webinar. We hope that you got something out of it, and we look forward to seeing you in the future webinars. The next one's April 10th at 2 p.m. Eastern Daylight Saving Time now. How about that? And we hope everybody has a good week. We're out of here. Thank you again.